A recent West Australian case has highlighted the importance of having a valid self-managed super fund estate plan to ensure that benefits held in a self-managed super fund go to the intended beneficiaries. The facts of the case are as follows. Francesca Conti established a super fund with her husband Augusto Conti in 2002. Francesca and Augusto were the individual trustees of the self-managed super fund. Sometime between 2002 and January 2005, Francesca and Augusto became estranged. However, Augusto did actually remain on as trustee of the self-managed super fund. In January 2005, Francesca made a personal will which appointed her children as the executors of her estate, and it even went so far to specifically exclude Augusto from receiving any of her entitlements, any of her assets on her death. The will also stated that any and all of her entitlements in the self-managed super fund be applied and given to her 4 adult children. In August 2010, Francesca unfortunately passed away, and she left a member balance in her self-managed super fund of approximately $650,000. Importantly, in regards to the facts of this case, Francesca did not have a valid binding death benefit nomination in favour of her children at the time of her passing. In February 2011, Augusto appointed a special purpose trustee company, of which he was the sole director and shareholder, as trustee of the self-managed super fund, and then proceeded to pay himself 100% of Francesca's benefits. Now, Francesca's 4 children were obviously unhappy with this, and they took Augusto to court, and they challenged 2 things. They challenged the appointment of the trustee company, and secondly, they challenged the payment that Augusto made in regards to paying the $650,000 worth of benefits to himself. Now, the judge actually ruled in favour of Augusto, the estranged husband in this situation, stating 3 things. Firstly, that there is no requirement under the SIS Act, which governs self-managed super funds, particularly Section 17A, for the executors of the deceased trustee and member's estate to be appointed as the trustee of the self-managed super fund, i.e. Augusto was well within his rights to remain as the sole trustee for up to 6 months, and then he appointed the special purpose trustee company, so he was totally okay doing that. So that gets the tick of approval. The second thing that the judge commented on was that the trustee of the self-managed super fund gives total discretion to the trustee in regards to whom the death benefits are paid when the deceased member does not have a binding death benefit nomination in place at the time of death, which was the case with Francesca. Unfortunately, she did actually previously complete a binding death benefit nomination. However, the wording of that, either the wording of the deed or the wording of the binding death benefit nomination document itself, actually put a 3-year limit on it. So it was only valid for 3 years, and unfortunately Francesca passed away after that 3-year period. So at the time of her death, she had no valid binding death benefit nomination. And the third thing that the judge commented on was that the deceased will, their personal will, has absolutely no impact on who controls the self-managed super fund in regards to the payment of the benefits. It's totally controlled by the binding death benefit nomination document in conjunction with the trustee. What can we learn from this case? Firstly, the rules within the self-managed super fund trust deed are extremely important. A good quality trust deed is absolutely paramount. The self-managed super fund should have had a corporate trustee either when it was first established or when Francesca and Augusto became estranged. This would have allowed Francesca to continue the self-managed super fund as a single member without needing to keep Augusto on as the second individual trustee. Binding death benefit nominations that don't expire and don't lapse should be in place for all members as an absolute minimum, and they should also be updated whenever there's any significant changes, such as a separation, as what happened in this case, occur. A person's will doesn't have any mechanism for dealing with or directing what happens to benefits to be held within a self-managed super fund. The will only covers assets of the estate. So for the will to have any control over assets which are held in the SMSF, the trustee would actually need to pay those assets to the estate and then to be dealt with. Unfortunately, if that happens, they can be challenged. There could be additional taxation consequences. It leaves the tax effective super environment. There's a whole raft of reasons why a self-managed super fund shouldn't pay benefits direct to an estate. And the final thing that we can learn is that executors of a personal will do not automatically become trustees of a self-managed super fund. In this case, Augusto was the remaining individual trustee, and he had 6 months to either appoint a second individual trustee or to appoint a trustee company, which is the option he chose. That last point is extremely important. So, how can super fund partners help? We have significant experience around this very technical area of SMSF estate planning. We can work with one of our specialist SMSF lawyers to build a comprehensive estate plan which includes the utilisation of a corporate trustee and provision of high quality self-managed super fund trust deeds, i.e. if you've got individual trustees or an old trust deed, we can both appoint a corporate trustee and upgrade your existing trust deed. We can also review, in conjunction with our lawyers, your personal wills to ensure that they do not inappropriately try to cover the benefits in your self-managed super fund. And unfortunately, although most family lawyers are very, very good, because self-managed super funds are such a specialist area, sometimes the lawyer's knowledge lacks, so they might inappropriately try to cover off on benefits which the personal will has absolutely no control over. We liaise with our specialist estate planning lawyers to provide a very high quality testamentary trust personal will, which can ensure that your wishes are carried out in the simplest and easiest way possible. We can also organise an enduring power of attorney that deals with control of the self-managed super fund due to death or loss of capacity. Now, one of our friends at Super Fund Partners is Bryce Figo from DBA Lawyers. What Bryce basically says is that if you have a self-managed super fund, it's absolutely essential you have enduring powers of attorney. We totally agree with that, and loss of capacity is a big thing that everybody needs to be aware of. We can also help with creation of a comprehensive self-managed super fund estate plan, which does include non-lapsing binding death benefit nominations. And the biggest thing is that we can assist with is ensuring that the correct parties have the control of your self-managed super fund accounts and investments if you pass away or lose capacity. Now, we can also help out with strategies which can eliminate death tax, which is a tax a self-managed super fund has to pay in regards to payment to adult children especially. And we can also work with you to create what's called almost like a legacy tax shelter within your self-managed super fund, which you can actually pass on a huge benefit to future generations, saving potentially hundreds of thousands of dollars in tax. So all up, we can design a workable and practical self-managed super fund estate plan where children from previous relationships and other beneficiaries you want to include can all be catered for. So please get in contact with us today and discuss any questions you have regarding your self-managed super fund estate plan.